Good morning, distinguished delegates, colleagues, ladies and gentlemen. Thank you so much for joining us this morning for this important event. We're happy to see all of you in spite of this weather. I want to believe that we all, is it working? Okay. Okay. Okay, thank you. I want to believe that we're all here because we are all supporters or proponents of DRR, DRM, and we are here to listen to the presentation of this very important project of IFRC and UNDP. I am Cecile Rebong. I'm the permanent representative of the Philippines here in Geneva, and I feel privileged to be asked to chair this meeting. Oops. Oh, I think now it's working. Oh. Okay, thank you. Thank you. I just want to give a brief background for this, but I know IFRC has circulated in their invitation what this event is all about. This briefing and panel are intended to serve as the launch of this joint project here in Geneva on the study on legislation for disaster risk reduction. This study covered 31 countries and looked to the main trends in their legislation related to 1, risk reduction, and 2, identifying best practices and gap areas, including the implementation of key rules. Oh, fantastic. Now we are on. While many countries have been updating their national legislations for disaster risk reduction in recent years, there has been very little comparative information available to them or to us on what has worked well and what are the lessons of other countries. This panel is one of several events that IFRC and UNDP are organizing in various cities. I understand that several launch events were held already in New York, in Washington, D.C., and in Germany. Well, one important announcement, I was asked to remind all of you that we are being filmed. We're on webcast. So, we have to smile. Now, this is also being recorded for those who cannot join us in person. Following the panel and discussions, IFRC is inviting all of you to some light refreshments outside this room. Coffee would be very good, isn't it? The significance of legislation on disaster risk reduction, or DRR, is evident in the Philippines, my country. Before 2010, what we had in the Philippines is called National Disaster Coordinating Council. But thank God, we realized that you don't coordinate disasters. You coordinate preparations, mitigation, and disaster risk reduction. So in 2010, we passed the law, it's Republic Act 10121, which is called the Philippine Disaster Risk Reduction and Management Act, that proactively promotes disaster mitigation and preparedness measures. This is composed of all government departments, including the private sector and NGOs. It also provides allocation of resources and allows local government units, which is, I think, a very important feature of this law, to spend as much as 70% of their allotted calamity fund for timely and responsive risk reduction efforts, and 30% for quick response activities. Let me now explain, ladies and gentlemen, the proceedings that we're going to have this morning. We have 1 hour and a half for our briefing, and we hope to finish our presentation by 11 o'clock and have 30 minutes for our Q&A. We will begin our session with brief welcoming remarks from Elise Baudot and Angelica Planitz. Elise Baudot is the General Counsel and Head of the Legal Department of the IFRC. Elise joined IFRC in 2000 as a member of the Legal and Governance Support Department. Since then, she has developed the Federation's legal portfolio into a fully functioning in-house legal service, providing support to the Secretariat, governance, and national societies in areas of legal risk management and substantive international and national law issues. Prior to joining IFRC, Elise worked in the project Finance and Corporate Practices. Angelica Planitz is the Disaster and Governance Advisor of the UNDP Bureau for Crisis Prevention and Recovery in New York, where she began in 2012. Before joining UNDP, Angelica managed the Pacific Sub-Regional Office of UNISDR in Fiji. She also worked with UNISDR in Bangkok, with UNDP BCPR in Geneva, with Concern Worldwide as manager of the Disaster Preparedness Program in Laos, and with the UN South Pacific Disaster Reduction Program. We've really gone around. We will then have a summary after this of the study's main findings and potential implications from our author, Mary Picard over there. Mary Picard undertook this project when she was a senior officer in the IFRC Disaster Law Program, working jointly with the UNDP in New York. Mary has undertaken a range of projects for the IFRC and disaster risk management law and regulations since 2006. She was also the focal point with the SPEAR project for the most recent review of the Humanitarian Charter. Now based in Zimbabwe, Mary is an Australian who practiced law in Melbourne in the 1990s in the fields of employment and discrimination law. Following this, we will hear about the Mexican experience. Victoria is here with recent disaster legislation. And we have Ms. Victoria Romero, who is with the Mexican mission, Permanent Mission of Mexico to the United Nations. She serves as the Chief of Staff and Humanitarian Affairs at the Permanent Mission of Mexico. She is a career diplomat working on humanitarian affairs for the last 6 years. During this time, she has actively promoted Mexico's disaster risk reduction policies, having participated in the last 2 global platforms of disaster risk reduction. She has also been involved in the chairmanship of Mexico of the ISDR support group for the period 2013 up to this year, 2014. Ms. Romero promoted Mexico's membership to the Good Humanitarian Donorship in 2011, having held the co-chairmanship of the group together with Finland for the past year, 2013 and 2014. Finally, we will hear from Marco Toscano Rivalta about how the issue of legislation is being discussed in the context of the negotiations for the development of successor instrument to the YOGO Framework for Action. Marco is the chief of the Office of the Special Representative of the Secretary General on DRR, where he has worked since 2009, providing direct advice and support to Ms. Margaret Wallström. Prior to this post, he held several positions at UN OCHA in Afghanistan and New York, for UNHCR in Geneva, and for OSCE in Bosnia and Herzegovina, with a focus on humanitarian, refugee, human rights law, and rule of law and justice reform. So there you are, ladies and gentlemen. We have really very good panel here. Let me now call on Elise for her opening remarks. Elise.
Okay, thank you very much, Ambassador Rebang, for this very nice introduction. And I'm very pleased to welcome you here to the offices of the International Federation. And very happy to join UNDP in the launching of the results of this new study. This is, I think, our 5th launch together, or 5th or 6th launch together now. In addition to these 2 agencies, the IFRC and UNDP, this study has been a joint effort. In fact, it is based on a comparative law study looking at 31 different countries. So without those countries, we wouldn't be here. So let me begin by first thanking those 31 governments who did participate in this work, many of you who are actually here in the room. As many of you are aware, through the efforts of its 13 million volunteers, National Red Cross and Red Crescent societies have been working for over 150 years to reduce suffering from disasters and crisis. We, of course, are not only ensuring that needs are met in a disaster response context, but looking to build risk, to reduce risk, not build risk, reduce risk, and build community resilience. In 2012, national societies spent approximately 110 million on disaster risk reduction activities, reaching over 23 million vulnerable people across 112 countries. We do not expect this programming to reduce. We expect this programming to go higher, to go up. And we look forward very much to supporting the commitments that will be made at the World Conference on Disaster Risk Reduction in March of next year. Communities must be engaged in reducing their own risks. It goes without saying. And to do so, they require the support of partners, including civil society, private sector, and in particular their governments, whose role is a critical role. Legislation is a powerful tool. It can mandate behavior, funding, responsibilities, accountabilities. It can ensure action results. In the sector of disaster management, what's interesting is what we found is that legislation is an unexplored tool in a lot of ways. I mean, there has been, of course, UNDP, you've done a lot of work in helping governments in strengthening their national legislation. ISDR as well, you've also been looking in this area as well, as reflected by Priority 1 of the Hyogo framework. However, it's still for me an area we haven't completely explored to the full potentiality. To what extent can legislation continue to reduce inequalities, discrimination? Can it ensure accountabilities, liabilities, etc.? And in particular in disaster risk reduction as an area to mandate behavior and political attention to an area that may not always be on the highest agenda of governments. As auxiliaries to their public authorities, national societies are key partners in the development of law and policy. As many of you are aware, over the last 13 years, the IFRC has been working with national societies and their governments to explore more systematically this marriage, if you will, between law and disaster management. This work began with a focus on the normative frameworks applicable to international relief, otherwise known as IDRL. In other words, what is the legal framework that governs international response, international disaster assistance, in particular at a national level? What are the rules at a national level that allow access into a country? What are the rules that ensure quality and accountability of the behavior of international actors when they're in those countries, right? How do you ensure that you strengthen the local ability to work? This is the IDRL project. Now the International Conference adopted the IDRL guidelines in 2011. And we've been working now for the implementation of these guidelines with over 40 countries adopting new laws in this area. Building on this success and seeing, again, the power of this marriage between law and disaster management, we went to the International Conference of the Red Cross Red Crescent Movement, which, as you know, is every 4 years, brings together all the national societies with the government signatories of the Geneva Convention, with a resolution asking governments to review their disaster risk reduction laws and to work with the national societies and key partners such as UNDP in doing so. The conference readily welcomed this. Today is an important step, and this study is an important step in that direction, in that journey with governments in the review of their disaster risk reduction laws. How can law make disaster risk reduction a true priority as affirmed in the Hyogo Framework for Action? What kind of laws are the most important for reducing of risk? How can law promote the appropriate dedication of resources and institutional powers? How can law best create incentives and disincentives to prod society into safer behavior? How can law help to reduce inequalities, gender inequalities and other inequalities? Experience is the best guide to answering these questions. This study brings to you the experience of 31 countries in answering these questions. It is the beginning of a process. As you will hear in the different presentations, there is much more work to be done. We couldn't do it all, but it is a start on that journey. It identifies future areas of research where we need to keep on working, and it shows that this can be done. What was interesting that came out in the seemed like such an important study to have done. We also now look forward in working with the results of the study and working with ISDR and UNDP and other partners in the substantive input for Hyogo Framework 2. Moving forward as well, we're also looking forward to take this research and other research done and continuing this work in putting together for you what we would consider potentially a useful tool for you, which would be a checklist for lawmakers. What are the key aspects of DRR legislation that have worked, right? What has been the best practice zone? And can we put together a type of user-friendly guidelines tool for governments to review their national laws? And that we're looking forward to having a draft of that ready, pilot of it ready for Hyogo Framework 2 for the conference in Sendai and for the international conference then in 2015. With these quick remarks, I will pass the floor over to Angelica. Back to Ambassador Rebang. Thank you very much, and again, welcome, and enjoy this launch. We look forward to hearing your questions and comments at the end. Thank you.
Thank you, Ms. Boto, and I now give the floor to Ms. Angelica Planet. You have the floor.
Thank you, Ambassador Rebang. Elise, my dear panelists, ladies and gentlemen, I wish you all a good morning. It's a real pleasure for me to represent UNDP here this morning and to share a bit of the perspective from our organization on the report on effective law and regulation for disaster risk reduction. Actually, the report and the launch today marks for us quite an important milestone for the partnership between UNDP and IFRC. Our collaboration on the report started back in 2012, but of course at the time both our organizations could already look back over more than a decade of support to our respective constituencies in this area of work. In fact, UNDP had carried out a first stocktake of trends in the development of institutional and legislative frameworks for disaster risk management in 2005 at the start of the HFA implementation period. Now, the review at the time covered only 19 countries around the globe, and some of the findings, in fact, still hold true until today. For example, one finding was that we saw considerable gaps in implementation of laws and policies because of resource and capacity constraints, or because of unfavorable enabling environments because of political instability, conflict, or weak rule of law. Another thing we saw and we still see is that there is insufficient consultation and participation at the local level in disaster risk reduction. And thirdly, that there are weak accountability mechanisms for disaster risk reduction. But at the time, the UNDP study did not only look at laws, it also looked at the broader institutional environment, the policies, plans, and partnerships. And the focus was specifically on disaster management acts and bills only, and not so much yet on legal provisions that also ruled other sectors of development, such as environment, physical, and land use planning. So, and also since then, we have seen three very important shifts happening. First of all, there is now a much greater interest in the underlying causes of disasters, and the risks that are generated by flawed development processes. There is also a much growing demand in UNDP program countries to support legal reform processes to really ensure that disaster risk reduction is a priority. And thirdly, there is now a much greater variety in the type of DRR-related laws and regulations that we see in the countries. So we realized that approaching the end of the HFA implementation period, the current implementation period, it was time to take stock once more, especially since there wasn't a lot of systematic information available about what worked well when it comes to legislation for DRR, and what kind of laws could make disaster risk reduction a national and, importantly, also a local priority. Countries such as India, Indonesia, Mexico, the Philippines, Vietnam, and many others have already made quite some progress in bringing DRR to the center of development practice. And they've done this by establishing quite distinct legal mandates across the sectors. And this, we felt, was also worth studying in much greater detail. And this is also where UNDP's interest mainly lies, namely to really look at where is the link between disasters and development, especially also in poor countries and communities that are disproportionately affected by disasters. Our support has also been geared towards taking advantage of the recovery process to build resilience for the future, because events such as Typhoon Yolanda in the Philippines and, of course, many small and medium disasters that are occurring regularly show us how quickly such events can erode human development gains and give rise to increased poverty, discrimination, gender equality, land tenure disputes, environmental degradation, and the list can go on. However, this does not have to be the case, because laws can play a very important role in addressing such inequalities that are related to these processes. The study therefore marks an important step to increase our collective understanding of the most important lessons for countries that want to really seek improved disaster risk reduction through the legislative route. It offers a number of practical solutions for how to define useful laws, but also how to ensure that they are applied and implemented. The collaboration between UNDP and IFRC was also inspired by a common interest in shaping the successor, the HFA successor agreement, which will be adopted next year in Sendai in Japan at the World Conference. And although legislation is already recognized in the current HFA as a critical tool for risk reduction, the question how we could actually bring it out more strongly in the future and in a way that is based on evidence and a broader spectrum of country experience was a driver of this work. And in that sense, we really look forward to collaborate further with ISDR also on this. Now, with these deliberations, and to give time to our other speakers, of course, let me come to a close here. I would like to thank in particular the IFRC, Elise, David, as well as the author of the report, Mary, for the very good collaboration over the past 2 years. Now that we have laid the analytical foundation, there is more work ahead of us, and the focus will be very much on developing practical tools and guidelines for lawmakers, such as the checklist that was already mentioned. So again, on behalf of UNDP, thank you also IFRC for hosting the event here. I think this is a very nice venue. I hope that you will be inspired by the findings and some of the key message that you will be hearing in the course of this morning. Thank you.
Thank you very much. I'd like to thank Ms. Elise Bodeau and Angelica Planitz for those very important statements. And indeed, they have emphasized that we can no longer have ad hoc arrangements in our countries with the natural disasters that we all experience, brought by so many things, including climate change. Legislations are really necessary. Now we go to the main event of this launch. We will now hear from the author, Mary Picard, and she's now going to present the joint this study, which she authored. Mary, you have the floor.
Thank you, Ambassador Ribong, ladies and gentlemen. Thank you for the interest you've shown in coming today. Obviously, in 20 minutes I can't give you all the details of the report, so this will be very much a quick overview of some of the key findings. Essentially, the work on this report began in 2011 with a series of country studies. The research actually involves 31 countries, but there are only detailed case studies undertaken in 14 of those, and so the report relies on the interviews with stakeholders and at all levels of government and civil society organisations and other international organisations involved in the countries to get a better understanding of the implementation issues. As Elise mentioned, part of the impetus, a very important part of the impetus for this study was the HFA, and in particular the first priority, asking countries to look at the policy, legislative and institutional frameworks to enhance disaster risk reduction. And the other aspect that Elise also mentioned was in relation to the 2007 resolution of the International Conference of Red Cross and Red Crescent Societies, which brings together the state parties to the Geneva Conventions. The midterm reviews of the HFA and the research that was done prior to the international conference noted that there was a lack of risk reduction focus in many laws at that time. There was also a lack of community engagement and information about managing risk. There seemed to be not a great deal of integration of civil society and the private sector in risk reduction, especially at the community level. And mechanisms for accountability for conducting disaster risk reduction were not strong. There were also identified some gaps in the authority, capacity and in particular funding for disaster risk reduction at community level, which resulted in difficulties and challenges in implementing disaster risk reduction at community level. So this is the 31 countries on which we undertook studies. So all of them we undertook desk research, which looked at the legal frameworks for disaster risk reduction in relation to disaster risk management laws, but other relevant sectoral laws as well. So they were undertaken in all regions of the world, and the case studies in particular focused on lower and middle income countries with a high disaster risk profile. The one exception to that was New Zealand, which was a high income country. It was selected because it had recently suffered a major earthquake, and some of the models of the law reform that they were undertaking were of particular interest. In looking at the legislative building blocks for disaster risk reduction, as I mentioned, we weren't just looking at disaster risk management laws. So disaster risk management laws, DRM laws, may be called civil protection laws or sometimes still national catastrophe laws, emergency management laws. The name of the law appears not to be very indicative of what's in it, because people often keep the same name that they've had for a long time because people are familiar with that. And I think you'll see the example in relation to Mexico, that it's still called a civil protection law because that's the terminology that people know, but in fact it's a very comprehensive law. So we actually had to look beyond the titles of the laws and beyond the priorities that they set, and look at what institutions they established and what were the priorities for those institutions, how they were taken down to the local level. But another really important part of legal regulation for disaster risk reduction is sectoral and local government laws and regulations for planning urban development. So safety in urban and rural development, particularly because of the increase in urban populations and the predicted increases of the global population being in urban areas. And so housing and settlements and land use are a really important aspect of the relevant regulation. We also looked at some cross-cutting and meta laws, which I won't have a chance to really touch on today, but these include constitutions and human rights laws, which set out some of the rights of the residents of countries and the obligations of countries in relation to protecting life and property of the people living there, as well as questions of legal liability, whether civil or criminal, and whether relating to government or private actors. Another area that we began to look at but needs further research is insurance for sharing risk, and also customary laws, which are particularly relevant in Africa and the Pacific region, particularly at the community level, where the local traditional customary laws remain very important in terms of community coherence and community approaches to risk reduction. So I'll touch on just some very key findings of the study. In terms of disaster risk management laws as such, significant progress has been made in providing a legal basis for disaster risk reduction. Many countries, since the Hyogo framework, have actually undertaken reviews of their laws and introduced higher priorities for disaster risk reduction in those laws and in the policies and strategies that they use to implement them. They have also given clearer mandates to their national institutions, or in many cases established new laws and new institutions to take a more systematic approach towards disaster risk management, including DRR. And many of these, in fact most of them now, include fairly clear local responsibilities. Sometimes these are through specific new institutions established by the DRM laws, and sometimes they are allocated responsibilities to local government, or a blend of the two. There's also been some progress, but this is more variable, in supporting DRR education and awareness. Most of the laws have some provision in them saying that this should occur, but it's sometimes a very general provision, and it's difficult to know whether it has been implemented or not, and there's often not a very clear set of processes to implement that. And another area is early warning systems, which again the laws tend to say these should occur, but actually making sure that this happens and includes all the relevant institutional coordination is not always occurring. So some of the key gaps that we identified in relation to just the DRM laws, in decentralised implementation there remains a major challenge that local government and local institutions have the responsibility but often lack the means, whether that's capacity or actual financial resources. So the funding mandates are often not established in the laws, or not established clearly in the laws. There are obviously many different mechanisms that countries use for funding DRR at local level, but there seems to be a lack of clarity and a lack of very clear priority given to DRR for implementation. Also, there seems to be a few examples where there is very strong accountability for government at all levels in actually carrying out the disaster risk responsibilities allocated to them. Even it seems to be more uncommon that there's public reporting and websites giving a lot of detail. So some countries are doing that, but a lot are not doing. And early warning and risk mapping, there are still a lot of gaps in these areas in terms of the legal regulation and also the practice. So obviously many aspects of both early warning and risk mapping don't require a legislative basis, but particularly for ensuring policies are clear and that inter-institutional coordination is clear. These are the areas where legislation really plays a part. And so some of the laws actually ask for early warning systems, but they don't necessarily have a systematic way of doing the risk mapping for a start. So that's another area where there's room for considerable improvement. And two other areas that were really highlighted in the country studies was that there is still in many cases a lack of engagement with the key stakeholders in the process of disaster risk reduction. Some of the laws actually make provisions for representation of civil society organisations, for example on their national and regional committees to do with disaster risk management. Some of them also have special provision for women on those committees, but these provisions are the exception rather than the rule. At the community level, there is often no interface between community level disaster risk reduction and official early warning systems and official disaster risk reduction. So the laws could do better by actually making clear provision for the involvement of communities at that level and civil society organisations. In particular, there seems to be very little specific engagement of women and of marginalised groups in whichever of the marginalised groups in the relevant society. There seems to be little voice for example, ethnic minorities and people with disabilities. So again, in relation to DRR education and awareness, as I mentioned before, there are broad mandates, but very often not very specific mechanisms for ensuring that this occurs. So I think we'll hear from Mexico that there are some ways of making that more specific. This is a very complicated looking slide, and I won't try to go into it in detail today, but the reason I'm putting it there is because we've often had requests from government administrators and legislators saying, well, can you give us a model law on how we do DRR, or some model wording, or do you know another country whose law we could adapt to ours? And really what came out of this study is that disaster risk reduction legal regulation is very, very context specific, and the success of it depends on it being well integrated into the governance system of the particular country and matched to the disaster risk profile of that country. So what we in fact did, rather than talking about model laws, was to develop a typology of disaster risk management laws and talk about those in relation to the strength of risk governance in the country through other sectoral laws. So some countries might need a more complex law that gives high priority to disaster risk reduction, but other countries that actually manage risk very thoroughly through a range of other sectoral laws may not need such a complex law. So I won't try to go into that more. It's explained better in the report for those of you who are interested in that. So disaster risk management laws are only one, actually possibly in many cases minor part of a country's legal regulation for managing disaster risk. So there are many other areas, including building codes, land use planning, environmental management, in particular environmental impact assessments for new developments, climate change adaptation laws, which are an increasing area of regulation, and generally development approvals for managing urban development. So I'll just touch on a few of those. In relation to building safety and land planning laws, it's interesting that almost all the countries actually have quite comprehensive building codes, and most of them have quite comprehensive land planning laws as well. All of them rely on local government implementation, even if it's a national law or a state law in a federation. When it comes down to it, it's actually the local government level that has to implement these laws and make the specific regulations and supervise the compliance. So in these laws there are some gaps in coverage which can be, those countries could look at in their reviews, and there are there's some lack of mention of natural hazard risks, particularly the risks from climate change, but the laws are broad enough to actually cover most of those sorts of risks. So on the whole, the legal frameworks for building safety and land planning are there, and the biggest challenges that were identified in the studies was in the lower and middle income countries, where the stakeholders repeatedly said that there was insufficient local resources and capacity for implementation. But another aspect of this is that this sort of thing can't be just done in a top-down way. There has to be a recognition that this is important from the community and from the affected communities. And we sometimes talk about this in terms of a compliance culture with the safety regulation. So it can't just be done by top-down policing, and so it also has to be supplemented by community education and awareness, and the communities need to agree that this is actually important for their own safety and for reducing their own risk. So this is an aspect that seems to be necessary to accompany these kind of laws. There's also very little use of any kinds of sanctions, and there's some areas where the laws actually provide for penalties if someone, for example, builds a 6-storey building when they only had a permit to build a 3-storey building, or to require them to demolish the building, etc. But there hasn't been much of a culture of this kind of use of this kind of sanctions in many countries. And so that's an area that we think countries could look at, and that's also related to the culture of compliance, because whether people accept that. So these things are all interlinked. Informal settlements, or slums, or shanty towns, as people call them by different names, are a major problem in many of the sample countries, and many of the residents in these settlements actually are exposed to much higher levels of risk from natural hazards. And these risks are growing as these settlements grow and as the urban populations grow. Only some of the sample countries have special legal regimes to manage the risks in informal settlements. So in the absence of a special regime, the legal position is that they are essentially illegal, but that doesn't actually help with managing the risk. So some countries, for example, such as Brazil, have introduced special legislation. Brazil has the Statute of the Cities, which aims to gradually integrate informal settlements into the formal municipal regulation. Others have provisions for sometimes removing residents, and those that have provisions for respecting the right to housing and the procedural rights of residents are one approach that seems to be more effective. But particularly if there is a need to move communities, that this is done in consultation with the communities, because the history of these sorts of provisions is that they tend not to work, and their settlements re-emerge if that's not done. So another area is environmental and climate change laws. Environmental laws tend to be administered very separately from anything in relation to disaster risk management in most countries, and also often quite separately from building codes and land planning, because of the way these systems of administration and law have evolved. So climate change and environmental laws do need to be better integrated with disaster risk management. Climate change law is a growing area, and it tends to be given to ministries of the environment, so there is capacity for coordinating these two areas, but there's some danger that this area of regulation is becoming another silo, and it's not being integrated with disaster risk management. An area that has particular potential and which doesn't seem to be being used at the moment is environmental impact assessments. So these have, before major developments are approved, there is a process for review of their impacts on the environment, and at the moment these don't very often specifically take into account natural hazard risks, and in many cases they don't give a voice for the communities. So this is an area that actually there is great potential to use as a tool, legal tool in disaster risk reduction. So some of the implications of the study include noting that there has been real progress, that there are many more laws that include disaster risk reduction, but that not all are making it a real priority, and very few are allocating specific resources. So it still seems to be a very under-resourced area. And the need to mainstream disaster risk reduction into sectoral planning and climate change laws is also very apparent from this study. And another really important thing is the idea that you can't just adopt and forget the law. It doesn't administer itself, and it needs community support, and it needs resources, it needs government commitment, it needs policies and strategies for implementation. And it also needs mechanisms for accountability. So these are some of the areas that could be enhanced greatly in the study countries, and probably a number of other countries as well. And finally, there is a need for stronger mandates in the laws to engage communities and civil society. It's very clear that governments can't do this on their own anyway, and that communities have a right to be involved in their own risk reduction, and that these two together are actually required to make disaster risk reduction regulation work at community level. In terms of the next steps from this project, as Elise mentioned, one of the initiatives that arising from this relates to national level work, so looking at a disaster risk reduction checklist for lawmakers. So we'll be continuing a consultation process on that, and looking at developing in consultation with governments country level tools for reviewing, making and implementing more effective DRA legislation, drawing on the results of this study. And on the international level, the Hyogo Framework Successor Agreement, looking at some of the possible indicators for monitoring progress on making laws that properly support disaster risk reduction and on their implementation. So some of the potential uses in the HFA tool, or the successor instrument to the HFA, in terms of preventing the creation of new risks, it would be quite possible to look at areas such as compliance rate for building codes and relevant development planning and environment laws. So there might be some quantitative indicators that can be developed as well as some qualitative ones. and the availability of and use of oversight mechanisms such as environmental impact assessments. So looking at the prevention of creation of new risk through urban development in particular. And then reducing existing risks, looking at the possibility of DRR regulation and plans for informal settlements and specific budget line items or specific budget allocation for disaster risk reduction, especially to the local level. And then finally, strengthening resilience, providing a legal basis for community participation within the laws, so that this is part of the responsibility of those administering the law is actually to ensure that communities are actively participating in disaster risk reduction, as well as mandatory DRR education, which can also be at community level and in schools. Some countries, such as the Philippines and Mexico, have integrated DRR education into schools, and so there is a dual responsibility in the education laws and in the disaster risk management laws. And finally, mandatory risk mapping and early warning systems in terms of having a legal underpinning to make sure that these actually occur in a systematic way. So thank you for listening today. That was a very brief introduction, but if you want more, there is this website, and also on the USB sticks that were with the summary reports when you came in, there's copies of the full report and most of the country studies, if you want to take those away. So I think that's all. Yep, thank you.
Thank you very much, Mary. Thank you for that very comprehensive, though brief, presentation. Before I give the floor to our next speaker, I'd like to, at this point, say that I think it will be good for IFRC and UNDP to have this kind of presentation at the national level. Because normally, and in my experience at multilateral diplomacy, we are diplomats and people who are in the international cities, multilateral cities, are so attuned to all of this. But we have to connect with the people and agencies and offices where this will be implemented. So that would be my suggestion. We can do this through UN offices in our capitals. I think it would be helpful to make this presentation before legislators, executive officials, NGOs in our capitals. Thank you. Again, Mary, I now give the floor to our next presenter. We now have Victoria Romero from the Permanent Mission of Mexico to the UN, who will make a presentation on the latest legislation of Mexico on DRR. Victoria, you have the floor.
Thank you, Excellency. Good morning, distinguished colleagues. Good morning, all. First, I would like to thank the FIRC for the invitation to this panel in order to share Mexico's experiences on legislation for disaster risk reduction within the framework of the launching of the report undertaken jointly by the IFRC and the UNDP. Thank you, Mari. It was a very interesting presentation, and I see it reflected some of the points that you made in my presentation. As you know, Mexico has been hit by several phenomena that have affected the lives of thousands of Mexican families. Every year we have hurricanes, earthquakes, droughts, and heavy rains affected our territory. Under these circumstances, we have responded with humanism and solidarity, uniting efforts and capabilities to succeed. Every natural disaster has left us great lessons. Among the challenges in civil protection is the increasing exposure to disruptive natural phenomena and physical and social vulnerability. Such events require responsibility and leadership to deliver and support preparedness actions to ensure public safety, physical integrity, and preservation of their heritage. This is why prevention of natural disasters is a subject to which the General Civil Protection Law attaches special relevance in the context of national civil protection system. The law has allowed us, knowing the dangers of risk, identify, eliminate, or reduce, and prevent or mitigate their destructive impact on people, property, and infrastructure, as well as anticipate the social processes of construction, therefore. From the new perspective of civil protection, characterized by its preventive emphasis, we used to have one. It was very good, and we had a very good experiences, and it was response one. Now, from last year, we changed the vision of these policies that we implemented successfully, but in order to improve it. With this new system, prevention and mitigation play an important role for combating adverse consequences of natural and man-made disasters. For the first time in the history of Mexico, after 25 years of continuing action and commitment, President Enrique Peña Nieto established as one of its priorities the issue of disasters. We adopted the General Law of Civil Protection last year, which was a new version of the previous laws. And this law contains 6 recommendations, all linked to prevention. The first one was to create and operate national warning system, which allows us to have real-time information to increase Mexican safety in situation of imminent danger. This you can follow nowadays on the internet, and they will tell you exactly which part of the country is in risk. And we have, with all this new technology, we have almost minute by minute following of the situation. And also, Mexico City has developed a very good system for earthquakes. In every 19 September, we have a drill. And this drill has succeeded in participating over 1 million people just in the city, evacuating people from buildings in risk in case of an earthquake. The second recommendation of this new law is to start operating the Safe Mexico in the face of disaster. This program was established in order to have a national infrastructure that is better equipped to resist natural phenomena, and this is linked to what Mari has said, that all this new law and oriented to infrastructure and not built on disaster. That's the technical. Is that okay, exactly. The third recommendation is to launch a campaign to spread a culture of prevention, something that you mentioned, and civil protection, and this is linked to what I was telling you about the drills before. And now young people can follow in Twitter the minute-by-minute situation of in different, not disasters, but also prevention and weather forecasts of this minute-by-minute. The fourth measure was to update the National Risk Atlas to make it a more useful tool for development and land planning. This is very important because as well we have it now on the web page, and you can actually check it all the time. And for the first time we have these figures of accountability and legal liability that Mari already mentioned in her presentation. Now this will allow us, or allow authorities to realize when a permission was granted in an area that was in a high risk. The fifth recommendation is a national response to accidents, emergencies, and disaster program to allow timely, coordinated action by 3 levels of government with disaster relief protocols. Now, this recommendation is aimed at unifying or harmonizing the local laws with the national ones, in which if a disaster strikes in one local area, according to the magnitude, it can be applied all the national protocols, and they all will have a unified vision of what to do, and there is a very good coordination. The sixth recommendation is to create 5 national representative civil protection regions in order to strengthen coordination between the various systems. As I said, Mexico is a very diverse country, so it was easier for Mexico to have the territory divided, and then all the programs can be implemented in a better way. These 6 steps allow us to consolidate the civil protection in Mexico as a preventive force with a greater response capacity. Within this frame, this year, it was established the Civil Protection Council, which is headed by the President himself, and at the same time, the Coordination for Civil Protection acquired a national status, and it's along these 2 issues, it has the highest priority, and not as in the past, it was only when we had an emergency that all these offices are important, but with this new law, it's the office is important all the time. As I mentioned, this National Council for Emergencies is chaired by the President, and it brings together and coordinates the responsibilities of the 3 levels of governments of DRR, as I mentioned, according to what the emergency is. The aim is to act quickly, conveniently, and efficiently to any eventuality. This council is building lines and actions and targets for prevention and relief, including the National Development Plan that it was established for 2013 until 2018. And one of the most important issues of this plan is that while elaborating it, it was included inputs from all stakeholders, which is something that you also mentioned, Mari, in the report. For us, it's very important, and we have had very good experiences with the private sector, so it's been proved a very good tool. Mexico, as well as the international community, recognizes that one of the most important challenges for future generations is not only reducing the loss of lives, but also to strengthen capacities to promote social and economic development, and this task can be undertaken by enhancing international cooperation. The challenge is to move from actions focused on emergencies and disasters to a system that reaches a balance between risk prevention and expand the state's capacity for reconstruction. I have a presentation that I will provide to my colleagues here, and where you can see the details of the law and its regulations. Thank you very much, Ambassador.
Thank you, Ms. Romero, and congratulations on your very comprehensive law in Mexico. Our last presenter, but certainly not the least, is Mr. Marco Toscano Revelta, who will make a presentation on how the issue of legislation is being discussed now in the context of this coming World Conference on disaster risk reduction. Marco, you have the floor.
Thank you, Ambassador, and good morning to everybody, and thank you, colleagues, for inviting me. It's really a pleasure to be here to discuss such an important topic and report, and I really want to commend Mary from the beginning on this very important work, and of course Angelica and David for bringing this forward, and it is, I think, is a critical contribution, in fact, that this report makes in the way forward. I'll keep my my remarks short so that we have some time for question and answers. Fundamentally, the question of law, we know it's important. It is not new to now. It was very strong also in Yokohama, but certainly the Yokohama strategy that was adopted in 1994. But certainly it has received a strong impetus with the adoption of the HFA. So let's say that the HFA has marked a turning point in the way countries and international organizations have been looking at the question of legislation to manage disaster risk. Certainly there has been, as Mary's report well pointed out, an increase in legislation being adopted over the past 10 years. A lot of emphasis has been placed on disaster, on management, on managing the response and the preparedness. This is necessary and needs to continue because we do know that risk is increasing. So keep working on preparedness and response is fundamental. In that sense, also the work that again David has been doing on IDRL with countries is of course very important and relevant. At the same time, the consultation on the new framework have been pointing out that there is a need for bringing more focus and emphasis on the question of prevention, which has been also mentioned by my colleagues here at the table. Now, fundamentally, risk accumulation continues to increase. We do know that this is due to the existing development pathways that we're choosing as individuals and as countries. It has to do also with the climate change and variability. This to say that some of the measures are indeed in our hands to take, and law is a fundamental instrument in that sense. Now, what the consultation has been fundamentally saying is what has been said by my colleagues here. There is a very strong alignment between the consultation on the post-2015 framework for disaster risk reduction and what you have heard until now. If there is one fundamental point that is coming out of the consultation is that the work that has been initiated under the HFA Priority 1 must continue, and therefore we need to have a continuation of the work between and the transition between HFA 1 and the post-2015 framework for disaster risk reduction. We also do know that countries have developed a lot of experience. There is a lot of knowledge in countries, whether it is in the institutional context or in the context of local communities. That experience must be brought to the surface, must be leveraged, must be learned, must be shared. And that is certainly one of the challenges that we have ahead, but at the same time, we do have such a resource that is still largely untapped. And in that sense, I think that the report renders justice to this existing knowledge, and certainly more work needs to be done to this extent. Now, the consultations also have pointed out that we need to increase the focusing on managing risk. Risk is not going to go away, so we need to find ways of managing that. And as also been mentioned in the report, there are three clear avenues that we need to walk. The avenue of prevention, the creation of new risk, the avenue of reducing existing risk, and the avenue of strengthening the economic and social resilience of communities and institutions. Now, we do know that risk is the result of exposure, vulnerability, and the hazard characteristics, and therefore the focus of law needs to follow these three areas, but fundamentally work in the question of addressing the question of increasing exposure, because we tend to live in areas that are hazard prone. I don't think that we will be able to move away soon from river basins or coastal areas, so we need to find ways of managing that risk. And we do know there is an increased accumulation of people and economic assets in such areas. So measures in law that address the question of exposure and that address the question of vulnerability are actually fundamental. Of course, a third point that the consultations have brought forward is the question of governance. It's not new. It's been there for a while, but it's also not going to disappear very soon. The three fundamental aspects of this question have been already touched upon here. Is the question of institutional setup, and the coherence of lack of thereof in terms of institutional mandates, in terms of sectoral legislations, policies, and so on and so forth. Interestingly enough, the last IPCC report that came out in March this year actually points to the fact that lacking coherence in institutional mandates and legislation is in itself a source of risk. So we must certainly focus on that. Another critical point in the question of governance is the whole of society participation, has been discussed now, strong messages from the consultations, inclusiveness, equality needs to drive, needs to be the key drivers of the principles for the legislations to be further adopted. There is also a question of the whole of institutions engagement. Until now, there is being a strong emphasis on the executives, which is good, needs to continue, but is not good enough. In the sense that the executives, whether they are at the local level or at the central government level, certainly cannot share the burden alone. Other institutions and therefore the other, let's say, powers in the way our countries are structured, being that the legislative and the judiciary needs to play their role as well. And in that sense, the consultation have pointed out a very active group of parliamentarians that across countries are promoting legislation. We have seen some examples in the presentation at the table. And also to ensure this whole of society, which is also about, for instance, how do we engage and how we make sure that the private sector, for instance, is fully engaged in adopting measures to prevent and reduce existing risks. Therefore, the way forward is certainly about a regulatory framework that actually allocate responsibilities across the public and the private sector. Again, public institutions alone cannot shoulder burden. We, in this room, as citizens, we actually have a duty and we need to play our role through the choices that we make and through our daily behaviors. Certainly, there has been a growing recognition that disaster risk management needs to find its foundation in law. And that is absolutely a fundamental point. That has also been reiterated by the important studies that the Special Rapporteur of the UN International Law Commission, Dr. Valencia Ospina, has pointed out in his 2013 report. The Commission is laying important foundations for the duty, the international obligation to reduce disaster risk. So in that sense, this quest from civil society group, communities, people, institutions for a clearer regulatory framework is going to be strongly helped by the work of the Commission. Certainly, there has been, we do know there's a lot of practice also in civil society and communities and also in institutions, and therefore the future legislation needs to be able to, let's say, codify that existing good practice and translate the good results into guidance for the future. There are a few other points that I will simply touch briefly. The question of local authorities and communities and the need to further empower them has come out in the presentation, is coming big times in the consultation. There may be different models, whether it is decentralizations, devolution, etc. There, the colleagues that are familiar with the administrative questions, they will certainly appreciate the differences. So each country will need to find its own ways to make it happen, but certainly the empowerment of the local is fundamental, and we have seen that through the Resilient City campaign, the strong engagement of mayors in driving action at the local level, local community has been fundamental. The question of due diligence is also big, and it goes to the core of accountability. And of course, the question of due diligence is related to the availability of risk information. the possibility of accessing those risk information, the way they are formulated, the way the existing system are really open and ready to be used. Then, of course, the monitoring mechanism, the need for financial and fiscal incentives, the need to find a proper balance between legally binding and non-legally binding instruments. We do know that disaster risk reduction requires measure in different fields and areas. DRR is at the crossroad, let's say, between environment, development, and resilience questions, and therefore they made different measures to be adopted there. Last but not least, of course, there are some obstacles for this work to go forward, but we also do have the means to address them. The question of public awareness is big, has been mentioned also in this report. More work is needed there. And of course, the question of corruption is hampering really very much the ongoing efforts, and therefore goes to the core question of rule of law in our countries. I'll stop here. Thank you very much again for this opportunity, and again my personal thanks to Mary for this important report.
Thank you very well. We have a couple of minutes for our questions and answers. I would like to invite all of you to participate. You can address your question to anybody here in the podium. I think the topic is very interesting. We have just had a very good presentation, and we are now in the midst of participating in the important process of preparing for the World Conference on disaster risk reduction to be held early next year. So we have questions, comments in your mind. This is the time to raise them. Yes, sir.
Thank you. I'm Manny de Guzman from the WMO, and I'd like to address my question to Mary. But before that, I'd like to support the recommendation of Ambassador Ribon that this study be presented also at the national level. But I think more than the legislators who have crafted the laws on DRR, perhaps we can engage in dialogues or in briefings, executives from the national and the local government level who are directly involved in the implementation of the laws. So like in the case of the Philippines, the laws are pretty recent. There was a Climate Change Act passed in 2009, and this was followed by the Philippine Disaster Risk and Management Act in 2010. And there was lately also a legislation that provides funding for climate change adaptation. This was passed in 2012, the People's Survival Fund. And recently, I think last week, there was also a new law that covers early warning communication, that all the private mobile companies would have to disseminate early warnings from the early warning agencies at no cost to the subscribers. So these are some of the new laws, and probably about 4 laws there are now in the Philippines. But the question is also, I think the second point I'd like to raise, and which I think Mary also covered, are the gaps. But you mentioned these are gaps in the law. But I would suppose these are gaps in the implementation of the law. I don't know if that's what you meant. Because what I saw in the Philippines is that there has been a struggle, shifting the paradigm from a culture of responsiveness to a culture of prevention and risk reduction. And this was really a struggle, institutionally as well as in practice. And in fact, the law, if you will study the law of the Philippines, there has been now a bias, for the very clear bias on disaster risk reduction and management. In fact, there was a tremendous increase in the budget of the for DRRM. And if you will look at the law, as much as 30% of that budget could be used for quick response, so meaning for post-disaster response. And that means it could be less. And there should be more, or 70% or more, for prevention, risk prevention and risk reduction. But this has not been immediately implemented because there was a struggle in how to implement this. And I think only recently in April, the Department of Budget and Management came out with their circular together with the Interior and local government on how to utilize these funds. And these funds, traditionally, we had the calamity fund, which is 2% at the local level, 2% of the local government fund. But now, that used to be used all for response, but now they can be used for pre-disaster activities, so preventive and risk reduction activities. But there's also a struggle of the local chief executive. And now there are some local chief executives that are, they have they've received legal complaints because they have spent the money not in accordance with the law. So there was an issue once lately on how to guide the local chief executives on the use of the fund. Now, and also, the law demands.
Excuse me. Yes. I know you have very important message, but I guess can we end that question and we'll ask Mary to answer?
My message is
so
how can we continue more study on this and shorten the transition period for the implementation of the law?
Thank you, Mary.
Well, that's a difficult question, but in relation to the earlier points you made, you talked about are there gaps in the law or gaps in the implementation. Well, in some countries there are many gaps in the law as well. The Philippines has a very comprehensive law and is still in the rollout stage. So obviously there would still be some gaps in implementation, but in many other countries they don't have the law, especially in relation to early warning systems and risk mapping. So there are both, and it depends on which country you're talking about. But in terms of continuing further study, I think what we tried to do with this study is to provide some analytical tools and the beginnings of analytical tools for countries to use at national level for reviewing their own situation in relation to the legal support for disaster risk reduction. And I think probably at this stage it's better to be doing that then at the national level with the tools that are developed from this study, rather than because, as I said, it's very context specific, and so obviously we can continue to use the resources from this study to develop those local tools.
Thank you, Mary. I'll call on the representative of UNAIDS.
Thank you, Ambassador, and thank you to the speakers for an extremely informative morning. Just a couple of questions, 3 questions actually, and it doesn't matter who answers it. Firstly, I really would like to also congratulate Mexico for the example, because I think the example brought to the table perhaps a lot of fundamentals that the area needs to grapple with and somehow place well at national level in order to start making headway. So I particularly like the Mexico example, and I think perhaps we could also look at the examples in terms of what we can further draw from them as further allowing cross-fertilization of approaches. But my questions are as follows. One is, and this relates to your presentation, Mary, I understand the importance of looking at the gamut of legislation at country level and getting a sense of layers of existence of legislation and the relationships of all that and how useful the whole terrain is. However, as a lawyer, I'm also very aware that the constitution in a country pretty much is the frame of all sectoral legislation. And to some extent, the Constitution offers an opportunity for continuity of the law, irrespective of changes in government and structures. I haven't heard very much the analysis around what legislation exists in the Constitution that gives us a more standing frame. And I think that would be an important entry point to perhaps further exploring the next steps. The second is relating to gaps. I don't want to sound like a wet cat on a wet morning, but I think that the gaps, for me, go so much toward to sustainability and also to implementation that one wonders whether in the next steps one shouldn't also focus a lot on the gaps. I understand that the next steps is going to be about checklists and so on. That's looking at kind of positive tools. But I think we should also perhaps try and draw on the gaps a lot more and come up with mechanism of how to use those gaps, whether it's in advocacy at various levels or naming and shaming, I don't know, whatever other strategies. But I think there's need to use the gaps to make the case that without really addressing these gaps, it will be very difficult for us to make headway. Lastly, I think the last speaker, Marco, spoke of some very critical underlying bottlenecks. And I think the role of very broad issues of human rights, equality, participation, etc., that we somehow need to re-centralize. And secondly, also the negative components of denial of democratic values such as corruption needs really also to be discussed. Thank you.
Thank you. Angelica will reply to the second question, but Mary, would you like to take the floor first?
In relation to constitutions, which I think was your first point, we did look at the constitutional basis for government responsibilities in disaster risk management in the main report. I wasn't able to cover that in the presentation today, but it's also an area that we recommend as one for further study because these surveys didn't in that area didn't have the opportunity to really look at implementation and the use of the entitlements under constitutions in relation to disaster risk reduction. But that's certainly an area that is covered to an extent and that we're recommending for further study. Is that my question?
Okay, Angelica, then let's see if... Thank you, Mary. Angelica would like to respond to the second question.
Yes, I think your second question was about, in terms of the next step we take from here, whether we should not focus more on addressing the gaps in implementation of legislation rather than focusing on tools. But in some sense, one leads to the other. Because what we saw in the study is that laws that are most appropriate to the local context are most likely to be implemented. So in that sense, it's not a matter of having the best law that really addresses everything if there are no local capacities or resources in existence to implement, right? So sometimes the standard does not have to be all too high. So basically, it's not useful to look at some neighboring country's law that has the best, covers all aspects that we discussed. But in fact, rather to focus on what are the key next priorities in our country that we have to address and to make it realistic. And realistic means that setting priorities, for example, in a law, to say we are not looking at all of the built environment, but we set priorities. We look at schools, educational facilities, public infrastructure, etc., or very high risk. We focus only on very high risk areas. So there is ways to really make the law better, more appropriate, and better meaning more appropriate, not more comprehensive. And this, I think, is something that we can also address by working on the checklists and the guidance that we give to lawmakers. So one doesn't necessarily exclude the other. And by sharing the report with its many country examples, we actually hope that we give more ideas to countries how to go about making their laws or legislative frameworks more context specific and therefore more successful and effective.
Thank you, Angelica. And if I may say something about constitution or legislation, it's true that maybe constitution is I would say, the more permanent, strongest law of the land. But for countries, it's not easy to amend constitutions, but it's easier to come up with laws or legislate laws. Most of our constitutions were written when we probably did have this climate change and all this typhoon signal number 5, just like what we had in the Philippines. So I think that's the reason why now legislation would be a more efficient, easier vehicle to do for countries. But definitely, for those who can put it in the constitution, I think that would be good. Other panelists who would like to make a response? Ladies and gentlemen, I think that was the last question. I would like to thank all of you for coming. I'm happy that we have a big audience. In spite again of the weather, this is a very good or very important presentation. The work commissioned by IFRC and UNDP is really very important, and Mary did an excellent job. I hope all of us will try. As I said, the challenge is to bring this back to the people who will make use of the report and not just read it and keep it in our drawers. We are agents of our governments, whether we are diplomats, government officials, NGOs, humanitarian organizations. The challenge for all of us is to bring this report to countries and to stakeholders who will make use of them to definitely prevent risks, reduce risk, and create resilient communities. There were gaps, and I don't have to repeat because we don't have time. Recommendations in the document are very important. Believe you me, I have read the whole report, although written in very small prints. But I understand from Mary that the documents that would be made available, or what we have now, the summary, are eye-friendly. So please, let's do our work, let's do our responsibilities to the people here on earth, to our governments. Let's bring this to the attention of those who will implement them. And again, I'd like to thank UNDP and IFRC for coming up with this project. I'd like to thank our panelists here, Mary, of course, Victoria, Ms. Romero, Marco, thank you very much. And of course, Elisa has now been replaced by a gentleman. Thank you so much for this presentation, for coming to this event. Now, before I end, I'd like to make a very important presentation. And of course, my country has something to do with it, including other organizations who are putting up this conference. The Philippines is hosting the second Disaster Response Dialogue. This is DRD, in September 11 and 12 in Manila. This is, DRD was first launched in 2011 by the Swiss government, UN OCHA, the International Council of Voluntary Agencies, and IFRC, with a focus on building trust and cooperation between international disaster responders and local authorities and civil society. And I would say not only local societies, but national governments, local authorities, and civil society. This will be the second major conference undertaken by this initiative and is expected to provide substantial input to the upcoming World Humanitarian Summit. So again, our hosting of this DRD conference is a manifestation of our commitment to DRR-DRM. And before I close, I'd like to take this opportunity again to thank all of you governments, NGOs, humanitarian organizations, for the very generous and kind assistance that you have extended to our people during Typhoon Haiyan. Thank you very much, and I would like to invite you on behalf of IFRC to our light refreshment outside. Thank you very much, ladies and gentlemen.